Hi, Lee Phillips here again. Yeah, I'm a lawyer, and I've spent a fair amount of my time doing what we call estate planning, wills, trusts, that sort of thing. The question often comes up, what's the difference between a will and a trust? They're both, in a sense, testamentary documents. That means they take care of stuff after you die. In fact, California now says that a trust, a living revocable trust, is a testamentary document. And it has to be executed as a testamentary document, which means it needs at least two witnesses. So a will is what people have traditionally used to say what happens after they die, how their estate's divided up. And it works. The problem is it has to go through court and be probated. If you die and you own property, and property's real property, it's the bank accounts, it's the safe deposit box, it's anything that requires your signature. If it passes at your death, either through a will or no will, but if it passes through the will, then it requires a probate proceeding. And probate's just our society's way of figuring out what happens when somebody dies to their property. And we have YouTubes on probate. So the will is probated, and the court takes charge of it, and the court oversees it until it dies or until all the property, the estate's wrapped up. The trust is very different in that you are transferring ownership of assets to this entity. Now, technically, a trust is not an entity. A living revocable trust isn't. But we'll think of it as an entity. This is pure heresy for me to say this, but think of it as a little company. We're transferring our assets to the little company, and in the document that creates the trust, we're going to say this is what happens after I die. It's divided this way, or it's held until the little kid gets to be 20, or whatever it is. We have one on different YouTube video on different ways that you can distribute property. So the trust acts as its own entity in that it can own property. It owns the property. That way when you die, we don't have to go through probate because the owner of the property didn't die. So it's a legal trick. It's an end run around probate and dividing up property or taking care of property or managing property after somebody dies. So the trust talks about it, and the trust has no teeth, doesn't take effect until a guy dies, and we go to court, and the court gives the personal representative, we call them now, the executor, executrix, and we've got YouTubes on how to pick that guy. But until the court gives that guy, your personal representative, power and authority to act on behalf of you, your estate, then the will's basically meaningless. The trust owns the property now, and it has control of the property, and the document creating the trust says that when you die, then this guy, or if this guy can't, this guy, or if this guy and this guy can't, then the third guy will take over as what we call a successor trustee. And that person has immediate authority over all of the property in the trust. They can sell it, they can do whatever they want with it. Well, they can't do whatever they want with it because you've directed what's going to happen to the property after you die in the trust document itself. And the successor trustee is obligated by law. It's called a fiduciary duty. It's a very high standard in the law. The successor trustee is required to execute and distribute or take care of the property the way you have written down in the trust agreement. So it allows him to do that immediately without court supervision because it's like he takes over as president of the little company and he has authority over all of the assets of the little company. Now, that's only an analogy. The lawyers just all cringed when I said that, but it's a good analogy, and you can think of it that way. We just got a new president of the company or a new trustee of the trust, and they have authority over all of the assets. So can you see the difference between a will and a trust? The will and the trust both say what's going to happen to the property after the guy dies, except the will requires the court to give it authority, to give the personal representative the authority to do these things and to sign on behalf of the dead person to transfer the property. In this case, you get to write it down and you say who takes over after, and the court has nothing to do with it. Of course, the trustee, like I said, is under a fiduciary duty, and that's a heavy duty to do what you outline in the trust to do. So I'd do a trust. Now, you're always going to have a will too, even though you have a trust, and we have a YouTube video on pour over wills, which is the will that is associated with a trust. So we'll have a will even if we have a trust. The will acts as the backstop in case something goes wrong with the trust. But use the trust. They're pretty cool, actually. Actually, they're really cool for your family after you die. If it's set up properly, if it's taken care of properly, and the care and feeding of the trust is something that is another 3 or 4 YouTube videos and something that the attorneys just don't teach you about. This is Lee Phillips talking on the difference between a will and a trust.